A 2009 case of Darrell J. Keehn versus the state of Texas. After seeing a propane tank containing anhydrous ammonia in a van parked in Darrell J. Keehn's driveway, law enforcement officials entered the van and seized the tank without a warrant. The Court of Appeals held that the seizure was lawful under the plain view exception, or, alternatively, under the automobile exception. We affirm its judgment, but hold that the search was lawful under the automobile exception. Keehn was charged with possession of anhydrous ammonia with intent to manufacture methamphetamine. Before trial, he filed a motion to suppress the propane tank containing anhydrous ammonia that was seized from the minivan parked in his driveway during a warrantless search. The trial judge held a suppression hearing. At the hearing, Deputy Monte DeFord with the Wichita County Sheriff's Office testified that he was investigating a theft at a house near 1811 Carmen Lane. Keehn and his girlfriend, Julianne Dixon Stevens, lived at 1811 Carmen Lane. Deputy Monte spoke with the victims, who stated they saw a male and female run towards the back of the residence. While investigating the theft, Deputy DeFord continuously returned to 1811 Carmen Lane to look for the van that was not there. He returned days later and saw the van on the driveway parked beside the house. Deputy DeFord decided to make contact at the residence of 1811 Carmen Lane, and as he walked up to the front door, Deputy DeFord looked through the passenger side window and observed a 5-gallon propane tank in the back of the van and noticed that the cutting of the tank had a bluish-greenish discoloration. Based on his experience, Deputy D4 concluded that the tank contained anhydrous ammonia, which is used to manufacture methamphetamine. Deputy D. Ford continued up to the front door and knocked, where he heard sounds coming from inside of the residence. After knocking for some time and received no answer at the door, Deputy D. Ford returned to his patrol car and radioed for backup. Because of the propane tank, Deputy D. Ford radioed for Wichita Falls Police Department's North Texas Drug Force. After other officers arrived on scene, Deputy D. Ford knocked on the house again when Keehn responded. Deputy D. Ford told Keehn he was investigating a theft and entered the residence to ask about the theft. Officer John Springens, a member with the North Texas Drug Task Force, arrived shortly after Deputy D. Ford and the other officers entered the house. Officer Springens received specialized training regarding the investigation and production of methamphetamine in Quanto, Virginia, from the Drug Enforcement Agency. He was also involved in investigating methamphetamine production in North Texas. Officer Springen stated he spoke with the other officers from the sheriff's department and Keehn inside the house. Returned and looked through the van's window where he saw the propane tank and noticed that the valve was discolored and looked like it had been modified in some way. Based on his training and experience, Officer Springens also believed that the tank contained anhydrous ammonia. Officer Springens entered the van, seized the tank, and tested the tank for ammonia. The test yielded a positive result, and Springens arrested Keehn for possession. Keehn stated when he was questioned about the van, he told officers the van was his friend, Trey Hopkins, and according to Keehn, Hopkins was trying to sell him the van and left it at Keehn's house for 2 months because he did not have any other place to store it. Keehn stated he drove the van for the first month, but after that he had not driven it. Keehn stated he did not give officers consent or permission to enter the van to seize the tank. The trial judge denied Keehn's motion to suppress and stated 6 points. 1. The defendant had standing to complain about the search of the van parked by his house. 2. The propane tank found in the referenced van was in plain view to officers as they made their way up to the front door of the defendant's house on the normal course used to reach the front door. 3. The peace officers had a right to be in the place where they were able to see the propane tank. 4. The propane tank had discoloration consistent with tanks that contain anhydrous ammonia. 5. The propane tank was not designated to contain anhydrous ammonia. And 6. The peace officers had probable cause to believe that a crime was being committed and therefore had the right to seize the propane tank from the van. On appeal, Keehn claimed the trial court erred in overruling his motion to suppress because 1. Deputy D. Ford and Officer Springens were not lawfully in his driveway when they saw the propane tank. 2. It was not immediately apparent to Deputy D. Ford or Officer Springens that the propane tank was evidence of a crime. And 3. Officer Springens' entry into the van was unlawful under the plain view exception to the warrant requirement. The court responded to the first argument and stated Fort Worth Courts of Appeal held that law enforcement officers had a right to be there where they observed the propane tank. With Officer Springen's training and experience, the court found that Officer Springen's testimony established that it was immediately apparent to him that the propane tank constituted evidence of a crime. Therefore, the court found that the plain view exception to the warrant requirement applied. After the court denied Keehn's motion for rehearing, he filed a petition for discretionary review, stating that the Court of Appeal ignored his argument about plain view doctrine did not justify the warrantless entry into the van. The courts went on to hold that, to the extent that Keehn's sole issue contained a sub-argument that the plain view doctrine did not authorize the officers to open the unlocked door of the van to seize the propane tank when, for the reasons set forth in the prior opinion that they had a lawful right to be in Keehn's driveway where they observed the tank, and which, for reasons set forth in our prior opinion, they had probable cause to believe constituted evidence of a crime, we expressly reject that argument. The courts also held in the alternative, police had authority to open the van and seize the tank pursuant to the automotive exception. In the discussion, when a trial judge enters findings of facts after denying a motion to suppress, an appellate court must first determine whether the evidence, viewed in the light most favorable to the trial court's ruling, supports these fact findings. If the findings supported by the record, appellate courts will afford almost total deference to a trial court's determination of the historical facts when they are based on an evaluation of credibility and demeanor. Appellate courts give the same amount of deference to mixed questions of law and fact if the resolution of those ultimate questions turn on an evaluation of credibility and demeanor. But when the resolution of mixed law and fact questions do not depend on an evaluation of credibility and demeanor, appellate courts are permitted to conduct a de novo review. The courts of appeal reached the correct result, but erred in the upholding the trial judge ruling under plain view exception. A seizure of an object is lawful under the plain view exception if three requirements are met. First, law enforcement officials must lawfully be where the object can be plainly viewed. Second, the incriminating character of the object in plain view must be immediately apparent to the officials. And third, the officials must have the right to access the object. Keehn focused on the third requirement and argued Officer Springens did not have a lawful right under the plain view doctrine to enter the van and seize the propane tank without a warrant. Plain view in absence of exigent circumstances can never justify a search and seizure without a warrant when police officials have no lawful right to access an object. However, the courts of appeal did correctly cite the automobile exception, even though it erred in relying on it as an alternative holding. Under this exception, police officials may conduct a warrantless search of a vehicle if it is readily mobile and there is probable cause to believe that it contains contraband. There are two justifications behind this exception. First, the ready mobility of a vehicle creates exigency, and second, an individual has reduced expectation of privacy in a vehicle because it is subject to pervasive government regulations. Keehn argues that the automobile exception does not apply in this case because the van was parked in his driveway. Keehn contends that an automobile exception applies only when a vehicle is located in a public place that is not regularly used for residential purposes. Keehn attempted to use California v. Kearney, quote, when a vehicle is being used on the highway, or if it is readily capable of such use and is found stationary in a place not regularly used for residential purposes, temporary or otherwise, the true justifications for the vehicle exception come into play, end quote. However, Keehn's reading of Kearney is incorrect. Kearney involved a warrantless search of a motorhome parked in a public lot in downtown San Diego, California. The court upheld the search, noting that although the vehicle possessed many of the attributes of a home, it was readily mobile and subject to regulation. The courts also stated an objective observer would conclude that it was being used not as a residence but as a vehicle. Given the particular facts of Kearney, the quoted text above strongly suggests that the location of a motorhome is extraordinarily important when determining whether to characterize it as a vehicle or residence under the Fourth Amendment jurisprudence, which recognizes that an individual possesses a greater privacy interest in a fixed residence. Kearney's reference to a place not regularly used for residential purposes in no way stands as a per se bar on the application of automobile exception to a vehicle parked in the driveway of a private residence. The automobile exception gave Officer Springens the right to enter the van and seize the propane tank. The van was readily mobile, as Keehn used it days before the search, and it was subject to regulation. Based on the training and experience concerning production of meth, Officer Sprangens had probable cause to believe that the tank contained anhydrous ammonia. Therefore, the seizure of the propane tank from the van parked in Keenn's driveway was lawful under the automobile exception to the warrant requirement.